The Trump administration has encountered an unforeseen legal blockade following successive defeats in the nation's highest courts. In a rare 1-0 AM order last Saturday, the Supreme Court, by a 7-2 margin, enjoined the administration from proceeding with deportations executed under its broad interpretation of the Alien Enemies Act. This decision, coupled with an adverse ruling from the Fourth Circuit Court of Appeals, has cast a long shadow over the administration's immigration and deportation regimen, signalling that its novel wartime claims will not go unchallenged. In response to these losses, the American Civil Liberties Union filed an amended class action lawsuit before Judge Jeb Boasberg in the U.S. District Court for the District Court for the... The suit targets the administration's decision to deport roughly 150 non-citizens in secret, without notice or a meaningful opportunity to contest their removal. These individuals were loaded onto late-night flights to El Salvador, where they remained detained in a facility notorious for reports of physical and psychological abuse. Central to the Accesi-Louis strategy is a pair of recent judicial precedents. First, in the case of Abrego Garcia before Judge Paul Zenas, the Supreme Court underscored that any individual deported under the Alien Enemies Act retains the right to challenge detention via a writ of habeas corpus. The plaintiffs argue that, just as the government must facilitate Abrego Garcia's return from Salvadoran custody, it must do the same for the first wave of deportees. Second, the so-called JG case, originally filed by the ACLU over a month ago in Judge Boasberg's courtroom, confronted the administration's invocation of wartime powers against a Venezuelan criminal organization known as Tren de Aragua. The Supreme Court's subsequent 6-3 ruling reaffirmed that removals executed under the Alien Enemies Act require prior notice and access to judicial review, even when the executive branch purports to be at war. Taken together, these decisions dismantle any claim that summary deportations of non-citizens are permissible without due process. The complaint painstakingly details 2 separate removal operations. On March 15, US authorities secretly chartered airplanes at dawn and transported 137 Venezuelans to El Salvador, issuing no warning and denying them any chance to contest the designation of enemy aliens. On April 17, a second operation unfolded more clumsily. Individuals received an English-only notice, despite their Spanish fluency, and were herded toward the airport by bus, only to be turned back after the ACLU secured to the Supreme Court. The ACLU filing asserts that these actions infringe multiple constitutional guarantees. The Fifth Amendment's Due Process Clause, the Sixth Amendment's right to counsel, and the Eighth Amendment's prohibition against cruel and unusual punishment have all been violated. The complaint also invokes the Administrative Procedure Act, arguing that the executive branch circumvented the procedural safeguards that Congress explicitly prescribed. A particularly poignant figure in the lawsuit is Andre Jose Hernandez Romero, an openly gay barber and makeup artist. He represents a subclass of 12 plaintiffs who share the plight of the initial deportees. Andre Jose and his fellow subclass members have been incommunicado since March 15, unable to speak with attorneys or loved ones. News of their alleged maltreatment in Salvadoran detention centers has only heightened concern for their safety. Leveraging these precedents, the ACLU seeks 2 principal forms of relief. First, an order compelling the US government to request and take all reasonable steps to repatriate the CCOT subclass from El Salvador. This includes directing American contractors and agents abroad to transfer physical custody back to US authorities and halting any payments to Salvadoran facilities that detain them. Second, a preliminary injunction to prevent further removals under the Alien Enemies Act pending full judicial review. The crux of the legal contest, however, may hinge on whether this matter can proceed as a class action. Judge Boasberg has previously questioned his jurisdiction over broad, consolidated petitions favouring individualised habeas corpus filings. The administration will undoubtedly challenge the propriety of certification in the DC venue, setting the stage for an immediate appeal to the DC Circuit and potentially the Supreme Court. These developments underscore a judiciary unwavering in its role as the Constitution's guardian. sad. Despite assertions that the country is at war with Venezuela, a conflict that neither Congress nor the Venezuelan government acknowledges, courts have unanimously rebuffed attempts to strip non-citizens of fundamental rights. As summer litigation intensifies, expect more 11th hour orders and emergency filings aimed at preventing executive overreach. For now, the Trump administration finds itself navigating a labyrinth of judicial checks. The Supreme Court's early morning intervention and the Fourth Circuit's parallel ruling signal that claims of wartime power cannot justify wholesale deportations. As this case unfolds, the courts will determine not only the fate of the 150 individuals in custody, but also the limits of presidential authority in matters of removal and national security. In defense of due process, the federal judiciary clearly intends to hold the executive branch to the rule of law. In anticipation of the Eclair amended complaint, the Department of Justice signaled its intent to swiftly challenge any effort to compel repatriation. In a prepared statement, DOJ spokespersons argued that the administration's exercise of authority under the Alien Enemies Act is well within the president's constitutional prerogatives when confronting threats posed by foreign-based criminal organizations. They suggested that the class certification motion improperly conflates individual habeas petitions with broad policy disputes and pledged to defend the removals on appeal.
Why do you?
It is likely that the government will file an expedited opposition to the preliminary injunction contending that the plaintiffs lack standing to demand return from Salvadoran custody and that El Salvador, as a sovereign nation, a dependent jurisdiction over the detainees' fate. Nevertheless, the Eclair invocation of the Supreme Court's 7-2 ruling in Obrigo Garcia, along with the 6-3 decision in the JG case, sets a formidable precedent that the executive branch will be hard-pressed to overcome without risking further judicial rebuke. Should Judge Boasberg rule in favor of class certification and grant the preliminary injunction, the government will almost certainly appeal to the DC Circuit. Under the court's emergency appeal procedures, an administrative stay could keep the deportations halted while senior judges consider oral argument. If the DC Circuit upholds the district court's order, the administration would face the prospect of returning to the Supreme Court for yet another 0 a.m. application, potentially as early as late May or June, seeking to overturn lower court directives and clarify the scope of presidential authority. That scenario promises to extend the legal struggle well into the summer, disrupting the administration's broader agenda and reaffirming the judiciary's capacity to check executive power at critical junctures. Beyond the immediate litigation, this dispute carries significant ramifications for the use of the Alien Enemies Act against non-state actors. By branding members of the Trenda de Aragua gang, an organized criminal enterprise from Venezuela, as enemy aliens, the administration tested the statute's applicability to entities that do not constitute foreign nations. Judges across 3 courts have now voiced unanimous skepticism of this approach, underscoring that the act was historically invoked only during formal wars against recognized sovereign states. A ruling that further restricts the statute's reach would hinder efforts to deploy it against terrorist organizations or transnational cartels in the future, compelling the executive branch to rely on existing immigration statutes and criminal prosecutions, rather than sweeping wartime powers. Internationally, El Salvador's government has maintained a discreet profile, acknowledging its cooperation with US authorities, but declining public comment on the detainees' conditions. Human rights organizations, however, have decried reports of solitary confinement, overcrowding, and denial of legal counsel at the Zacatraz Detention Center. If a US court orders repatriation, it will place El Salvador in the uncomfortable position of releasing individuals whom it has detained at Washington's behest. That outcome could strain bilateral relations and heighten scrutiny of US immigration policies abroad, prompting Salvadoran lawmakers and regional bodies to question the legality of outsourcing detention to third countries. For the families of those removed in the March 15 operation, each day incommunicado has been a trial. Spouses, siblings, and children of the CICOT subclass have mounted silent vigils at US embassies and local Seidamsu and localities anxiously awaiting word of habeas petitions and judicial relief. The ACLUHT complaint quotes anguished parents who describe months without a single letter or call, fearing that their loved ones face a physical punishment and psychological torment. Should the court's mandate return, those reunions will mark a vindication of constitutional safeguards. Should the litigation falter, the episode will stand as a cautionary tale of executive overreach. Ultimately, this case exemplifies the dynamic tension between national security prerogatives and the rule of law. The judiciary has consistently affirmed that even those designated as even as enemy aliens retain core rights under the Constitution, including notice of charges and access to counsel. As this multifaceted battle progresses through the DC circuit and potentially back to the Supreme Court, the federal courts will again be called upon to delineate the outer limits of presidential power. Regardless of the outcome, the proceedings will leave an indelible mark on immigration jurisprudence and the principle that no executive action, however expedient, may circumvent foundational due process protections.